speaker of the session.
Including child labor, domestic violence, legislative privileges and socio-economic rights, reflecting her commitment to advancing justice and equality through legal education and discourse. She has been resource person in various national and international academic endeavors. In addition to her extensive publications and speaking engagements, ma'am has been actively involved in research guidance, having produced 6 PhD scholars and currently guiding 6 more. She completed a UGC-sponsored major research project on assisted reproductive technology vis-a-vis women's rights. Her administrative experience is extensive, including roles as a syndicate member, Senate member, and deputy warden at Tamil Nadu Dr. Ambedkar Law University. Committees at several prestigious institutions. Her career reflects a profound commitment to legal education and advocacy, underscored by her significant contributions to constitutional and women's law. Now I request ma'am to take over the session and speak on right to a healthy environment, a critical study.
I hereby invite Ritu of 4th Sem 5 years to present a brief profile of our second speaker.
My warm wishes to everyone. I consider it a great privilege to introduce and welcome Professor Dr. B.C. Nagaraj sir to this august gathering. Sir is currently serving as the chairman and professor at Bengaluru University. Sir holds a PhD from Bengaluru University and PDM from Indian Institute of Sciences, Bangalore, specializing in ecology. Sir has held various important positions like chairman of the Department of Environmental Science, subject matter expert for ecology and biodiversity for National Accreditation Board from Education for QCI, etc. He has been advisor to Government of Karnataka in relation to conservation of rivers, trees and ecological sensitive zone. Sir is a seasoned academician and also an avid researcher who has grassroots level experience in doing complex researches, thus adding practical value to his teachings.
Good afternoon. Now we have 2 eminent speakers who will be presenting their views on the topics. First, I invite Dr. B.C. Nagaraj, Professor and Chairman, Department of Environmental Sciences, Bengaluru University, to address us on public participation in environmental impact assessment in India and overview. Sir, over to you.
Respected chairperson, principal sir, and all the faculties, the dignitaries of the seminar, and all the students, media and other communities. First of all, I thank the principal sir for inviting me and share my thoughts on this occasion. I also good friend of Hegde sir. Just Nagesh Hegde sir has completed his talk. Then I have principal sir has told me that I also speak in a similar line what Nagesh Hegde sir has told, and sir has advised me to talk on environmental impact assessment. So as all of you know that this is something tool is used by the government to clear the project for implementation. Any project is implemented that has to undergo the scrutiny of the government to highlight and illustrate about the nature of impact about the projects. That is something in the backdrop of sustainable development. As all of you are aware about, whole kind of sustainable development issue came in the Supreme Court, and the first conference held in 1972 in Stockholm on the global level, and then about Rio de Janeiro conference in 1992, and so many other conferences in the global level. has made this national government to think about the development is happening very rapidly at the cost of environmental degradations. That's something was the cause of concerns of all the nations in the world. Whoever the party to the Stockholm Conference and also the Rio de Janeiro Conference in '92 have signed this agreement, and then finally, formally, these global countries have said that some kind of environmental impact assessment has been done for the projects. First and foremost, the USA has done it in 1917, then Canada, Japan, and all developed countries have implemented this legislation of environmental impact assessment. As all of you know, the history of environmental this thing, and as illustrated by the previous keynote speaker, we got justice due to the advocates and judiciary. Starting from Mehta case to the Sinha case and so many Supreme Court cases, they're all like, they gave a justice, and we could not able to give a justice as an academician, activist, students, like the only that's the judiciary has given justice in the country. That's something you all should be proud enough to say that this conference will give some kind of message to the youths that judiciary plays very important role in environmental protection in today's world. So that I honestly accept as an academician, that's something judiciary has given a lot of justice. So when it comes to the environmental legislations, when Indira Gandhi came from the Stockholm Conference in 1972, there were not explicit kind of mentioning about environmental conservations in Indian constitutions. Article 52A is something like which is highlighted about this state have a sovereign rights to protect the forest, wildlife and environment of the country, which has been brought in the parliament in 1976. Then about this, the fundamental rights have been brought in the parliament. Then about right to life has been implemented and is changed into right to live in a clean and healthy environment. All kind of constitutional changes has provided this Indian government to implement the environmental act, environmental protections. So as you know, that's we got independence in 1947. So our country's agenda was people were dying due to this the famine, lack of food and lack of water and all kind of basic things for the fundamental things after the independence. The Nehru was ruled this country for 17 years as a prime minister of the country. This is given emphasis for agriculture. Food was the main thing for everyone. That's the lack of food. People were dying without food in those days, which all you read it in the textbook. Lifeline or agriculture. The guidelines. Then the second issue was the thermal. So that is a coal kind of based energy, is the dirtiest energy on earth that has to be reduced if things that all other kinds of guidelines, highway guidelines came, and the so many ministry. There was no exclusive agriculture ministry till 1984. Only the 1984 has given a statutory kind of power, and then the Ministry of Environment and Forest started in Government of India. Even though we got an independence in 1947, Environmental Ministry came in picture only in 1984. That's something you all can imagine about how much time it took to realize the importance of environment. That something is because that has been enacted because of Bhopal tragedy. That's something, if the tragedy would have not happened, even that enacting this Environmental Act would have been delayed further. That's something is you can relate into the industrializations and leakage of methyl isocyanate gas and a lot of kind of health issues. That's something Bhopal tragedies make the central government to form the Ministry of Environment and Forest in 1984. Then this Environmental Protection Act came in. That before that we have all the acts. Water Act came in 1974. Forest Act came in 1980. Okay, then Air Act came in 1981. Wildlife Act 1972. All the acts came before the Environmental Act. That is a kind of irony about this India. If you look at USA, 1970, Environmental Protection Act came in first. Then all other acts came later. In Indian legislation, if you look at it, all environmental legislation came before the Environmental Act. Environmental Protection Act, which is called as a umbrella act. All other individual act, Air Act in 81, okay, Water Act in 1974, Forest Act in 1980, okay, Wildlife Act in 1972, everything came before. Then this Air and Water Act have been merged into Environmental Protection Acts, and so many legislation came in pictures, and that was the kind of history. With all these judicial interventions and so much legislations in India, in 1994, the people thought that, the government thought that there will be some kind of reduction of the impact. All the industries, we have to be careful about giving permissions. Then the 1994 Environmental Impact Assessment has been guidelines implemented under Environmental Protection Act 1987. 1994, the first EAA guidelines issued under the statutory provision under this Environmental Protection Act of 1986. So this Environmental Impact Assessment Act in 1994 has made the industries to realize the role of environment. So you know that anybody, any industrialist walks into Chief Minister's office or Prime Minister's office, they give a red carpet welcome and they say that, okay, in principle you agreed this project, you can go ahead. That was a state of affair that has happened because of LPG. In 1991, when P.V. Narasimha Rao was there, that is privatization, liberalization, okay, and globalizations. That came in picture in 1991. The Indian government did not open up any kind of export-import till 1991. This LPG reforms was the beginning for industrialization in India. Any country, any chief ministers or prime ministers interested in economic growth, not about environmental protection. That something is, they were giving in examples, economics were the culprit for that. All the economic advisors to any prime ministers and chief minister's office, their agenda is economic growth. That's something they were like, see the all European nations and developed nations, they've all grown the economy at the cost of environmental degradation. Okay, that's pollution. London smog is something 1934, 1940. Los Angeles smog. All these things you have studied in textbooks, and their industrialization has happened in beginning of the 19th century. They have seen the pollution, then they enacted the laws. That something was the advice of economists to the prime ministers. All the time their emphasis was economic growth, and not much importance has been taken for environmental protections in India. Luckily, 1994, that's the environmental impact assessment came in pictures. There's some kinds of serious thinking was started in the government to start about giving permissions. When the government, industry need three kind of things for any industry to set up. One is land, one is water, other is energy. If any government of whether state government or central government give these three things, industry will come and set up there. So they are the three things, a lifeline for any industry. Any industry, economic growth means exporting more, import less. Then the GDP will rise. That is something like this impact assessment has been made as a mandatory. Environmental clearance, forest clearance, wildlife clearance, groundwater clearance, all kind of clearance came in fixes in 1994. The industries has to undergo for this clearance from the government as a statutory rule. This is something has made the industry to think about this kind of project sanctioning. There are 34 industrial sectors have been grouped, and there are sectors have mentioned as EC, environmental clearance is not required, environmental clearance is required, and modalities and everything has been framed in these guidelines. Those who are interested can download and read 1994 EIA legislations. That is something was the beginning of EIA in Indian situations. These public consultations, okay, when you say environmental impact assessment, don't think that is only the science is there. Okay, that's environment has three components. One is a physical environment, okay. Second one is a biological environment. Third is a social environment. Social environment is communities, people. So environmental impact assessment, they made mandatory to have a public hearing process. Any scientific document is being prepared by any kind of industry or a consultant, it has to undergo for public scrutiny. How this has to undergo the public scrutiny? They have to conduct public hearing process. Me as a professor is involved in the environmental impact assessment project. I will prepare a scientific report, and that will be submitted to the government. That scientific report submitted the formalities of the public consultations, because the conference is basically emphasizing on public participation. In the environmental clearance process, when the report is prepared, I was part of the many reports preparations in India. So when the report is submitted, that is submitted to the Pollution Control Board for public hearing. Pollution Control Board issues in the newspaper about public consultation on dash and dash date on the particular site. This public consultation has to happen where the industry comes. Particular village, taluk or district, it has to come. The whole kind of public hearing has to be done by district collector. IAS officer of the district is the chairman of the public consultation process. All the stakeholders are invited and given their suggestion, and this report before the meeting, the local language report is communicated through this website of the Pollution Control Board, and also the hard copies were kept in the district office, taluk office, everywhere. Anybody can walk in and read the report and give the opinion. Unfortunately, this kind of consultation process is not happening in Indian situation. I was involved in this process from last 2 decades, where publics were given a chance to say their comment by email, by letter or writing, by when the report is online or offline or in the offices, but not much kind of impact has happened in this public consultation process. All of you know that how public consultation is done. That has to be videographed. Okay, that has to be recorded. Each and every grievance has to be heard. Proceeding has to be made. Proceeding, sometime they were doing it after 3 months or 6 months. Now the legislation says that district collector's IAS officer has to write the proceedings on the 5 o'clock or 6 o'clock on the same day. He has to upload in the website. He need not to listen to anybody else. So all this kind of, and only one thing, this recent environmental impact assessment guidelines have been diluted is, earlier they said that anybody can come and give the grievances. Now they are saying in 2006 EA notification, only the projects who are affected by the project directly, they are the only can come and give their grievances. That means people residing in 10 kilometers radius from the project area can only attend the public consultation. It has made an anger on the NGOs and activists who comes from Delhi, wherever the public meeting held, and they're going and they're raising their voice. So they're saying that this some kind of politics is there, and people come from outside and they kind of tell sort of things to the local community and disrupt the meeting and all this thing. Then the government diluted it and they're saying that only people, your land you are losing, your forest you are losing, agricultural land you are losing, house you are losing, you only come and attend the public meeting. That is something is that diluted in recent years. So the law has been, it's there as a mandatory, but a lot of kind of changes were there in that thing. Okay, that public consultation was very, very important. Yeah, I told that 34 projects were there. You look at it, so many projects are exempted from the public hearing process, public consultation. What are the projects? Defense projects. Public consultation is not needed. Modi government has said that like a lot of projects are exempted. All the infrastructure projects exempted from public consultation. All kind of drinking water projects, Ethinole project is going on. Don't get confused. It's exempted from environmental clearance because it is a drinking water project. That's why people went to NGT, National Green Tribunal. No. The impact will be more than the industry. The water is lifted from 7 streams, lifted, stored in so many places, and then brought to Bengaluru. So impact is more. Environmental clearance is needed. No. It is drinking water project, environmental clearance not necessary. The public consultation, environmental clearance not necessary. Like that, a lot of projects were exempted. Steel bridge project is proposed in Bengaluru city. Okay, that is exempted. But public says came to the street, project has been stopped. So peripheral ring road exempted. All highways, railways, metro project. Metro is a very good example. It's exempted from the environmental clearance. Why? It's a public facility. It is not built for any individual. It is built for everyone. But when the High Court of Maharashtra, all of you are aware about Voka, he's a Supreme Court judge now. He was the one of his judgment in Mumbai when the metro rail is constructed. When he has passed a judgment stating that you have to retain the trees. Let the train go zigzag way, not straight, but retain the big trees on the road. Such a kind of judgment that the Maharashtra Mumbai High Court has given. The same person has came into the appointed as a Chief Justice of Karnataka High Court 4 years back. He has passed a very serious kind of judgments about Bengaluru Metro Rail Corporations. He told that these trees should not be cut. If you are cutting it, there should be a tree expert committee. I was a part of the tree expert committee is constituted by the High Court of Karnataka. So that's something which we are working on, that how to minimize the cutting of trees for all developmental works in Bengaluru city. That because of Voka judgments which realize the government, no, we can't go ahead. Even though environmental clearance is not there are a tree expert committee, so many other clearances is required. He made the rules. Now he is in the Supreme Court. So that like that, there are so many kind of infrastructure projects were exempted, but it's something judiciary has helped government to do that. It's still another 3 speakers are there. These are some of my remarks stating that like environmental clearance is a government legal clearance. Okay, so many NGOs are tracing it. This document available in the website. You can download it. We can read it. You can educate people. Take some judicial advocate help, and we can file in the High Court or Supreme Court. Then we can stop the project. Even after clearance of environmental clearance, the files have been filed in NGT. So many environmental clearance cases after clearance by the state government, central government, now they are under scrutiny by NGT. So NGT is very strong. Of course, its dilution is happening. All of you are aware about it. But still, a lot of things are happening in today's world. This judiciary is helping the government in taking a lot of kind of process. That is an evolving process. Environmental clearance, forest clearance, wildlife clearance, all these kind of very, very important legal instruments. It is a legal things. So you all can give and focus on these issues and safeguard this country's environment. With these words, I thank Principal Sir and the other dignitaries in the dais and the college management for giving me an opportunity to come and share my thoughts on this whole kind of legislation issues which are very, very important and need of the hour in today's world. Thank you very much.
Humans are the only creatures on earth that will cut down a tree, turn it into a paper, then write, "Save the trees" on it. In the words of Ted Klongoski, a healthy environment is essential to a living Oregon and a strong economy. May I now request Professor Dr. Reddivari Revati Ma'am, former Professor, Dr. Ambedkar Law University, Tamil Nadu, to speak on the topic of right to a healthy environment, a critical study.
A very warm good afternoon to one and all present here. At the outset, I must be thankful to the organizers, particularly the management of Keelpar and JES. And my special thanks to Professor Kempegowda sir, who is an outstanding student turned outstanding principal of Vivekananda College, for giving me this opportunity. All the way we have come from Chennai. And I must be very thankful. And we used to meet in various academic meetings in different parts of the places. So that association, sir, has recognized us to be here. Really, sir, you have provided me a wonderful opportunity. Otherwise, I missed a wonderful lecture in the morning. Presented by Professor Hegde. It was a wonderful, it is really a feast like environmental feast. And as my co-speaker already highlighted about the process, how to get environmental clearance and impact assessment and various legislations, how it has come into effect and all, I would like to focus as a law student. I'd like to pay my attention only on the right to healthy environment. So we know very well that in India, we have a popular saying that if that gone were the days, the old saying, if your wealth is lost, something will be nothing will be lost. Your health is lost, only something will be lost, and character will be lost, everything will be lost. You know very well that. But nowadays, this phrase, little we can change it into that. Health has become a priority area. If we lost your health, not only it is not something will be lost. It should be. We can say that it is everything will be lost. So everything, health in the sense, no, it's not necessarily our physical health, mental health, everything. So therefore. Healthy environment is a vital and fundamental part of life, human life particularly. And this right is more pertinent. Why? Because it allows a person to grow physically not only, and even mentally, intellectually healthy. So therefore, this right now, nowadays we talk much about health right. And if you take that there are no constitutional, we are all law students, you know that now all the rights conferred by the constitution, and one cannot, the state cannot take away, and these rights are getting violated, immediately one can seek the redressal. We can fight for, enforce our rights. Right, that is what, that itself is also a fundamental right. You know very well that. But if you take all the fundamental rights right from 14 to 32, there is no specific mention when the Constitution was drafted right to health. But the constitutional framers, the intention of the constitutional framers was recognized by the judiciary from time to time, and particularly, Maneka is a pioneering decision where right to life includes, it is not mere animal existence, it is something more than that. Right to live in wholesome environment. Right to health is an integral part of Article 21. So without having healthy environment, and if it is not there, we don't have any better health. So there is no meaning at all in conferring life. We cannot lead a better life. So it is not a life at all. So therefore, health right is recognized at one point of time, particularly after 80s, it has given much recognition for this. by the constitutional courts from time to time. And we know that the environmental issues nowadays we talk much about, and morning the speaker has shown that so many environmental issues. If you take those issues, no, and if these issues are not controlled, there will be no life at all. And this constitutional right, the mandate would be a futile effort. So therefore, what are the reasons for, what are the causative factors for these environmental issues? And how they are posing a threat to the major health hazards. All this, if you take into consideration, it is being addressed at international arena. Not only, it is not a matter of concern at India and at the international concern. And as earlier speakers all pointed out in the right from the mornings, that Sir Patil sir has also mentioned, and the previous speaker also mentioned, right from the Rio de Generation through Stockholm and even Brundtland report. That is a major contribution at international level. It was addressed, and these were emphasized much about this environmental intergenerational equity, public trust doctrines, more particularly the sustainable development. We are, now itself we are showing concern much about the health, right? But because of how it is getting polluted through environmental issues, not only that, what about future generations? We are consuming all. The major reason is the misuse of natural resources. The misuse, imprudent use of, and unjudicious use of this natural resources, reflecting in major health hazards, dangerous health hazards. And because of, as a result, what is, one is these two issues, misuse of natural resources, and the morning speaker has highly pointed out that imprudent disposal of waste management. This waste management, we are miserably failed in waste management, improper disposal of waste, including biomedical waste and e-waste. And take for example, nowadays we all going for, in olden days, still we remember, not olden days, some decade back also we are using some kind of lights in that. Now everyone, they are going for, it consumes lesser power, and then even more brightness will be there. All of us, we are going for LED lights. And if you take that, Philip company lights, you see that coil, like it will have a very brightness in the room, so that we are using most of them. We are using those lights, and compared to the earlier bulbs, all of it. See this, how to dispose this? How many of you have concern? All this, the first foremost one I would like to focus is, the topic itself is a very rightly chosen. What is that? Protection of human rights by environmental law. See, when you talk about human rights, why these human rights are violating? Very oftenly we are talking about violation of human rights in all walks of life, not necessarily from environmental angle, from every angle, all walks of life. Why it is? Because human rights, basically, it is duty oriented. So everybody, they follow their own duty. Where is the question of violation of rights? That question doesn't arise. We miserably failed to perform our duties, and easily and conveniently throwing blame on the state and other stakeholders of this governance. Sorry. So these are things that are happening. First and foremost, we have to duty oriented. So now I can take this the same example that bulbs. We are not properly disposing. At the most, if the bulb, once it is diffused. So what we are doing, normally, anyone can tell this bulb is getting diffused, what you will do? How to throw? That's what, throwing is inevitable, but how to throw? How you are throwing? Generally, we are giving in now waste collectors will come now. Arranged by the corporation, and then we'll throw it in a different covers and two different. We are biodegradable and non-degradable waste. Two different ways we are giving it, and just we are throwing. How do they dispose it up? And morning, our professor he has pointed out that we have to hand it only to the manufacturers. At least manufacturers should identify some person. We have to hand over it to them. What will happen if they throw it in a dumping yard and the bulb will get, once it breaks, and then the mercury and everything, it will be there. It percolates into earth and that pollutes water abundantly. So it's that polluted water we are consuming. How can we say something about, how can we speak about health rights? So we cannot, absolutely we cannot have, this is one example I have given. So we are where we are miserably failed to perform our duties. So therefore, as a result of this misuse of natural resources, there will be ecological crisis. And because of this ecological crisis resulting into global warming and acid rains, pollution, all natural resources like air, water and all, and of course loss of biodiversity, food adulteration, all this, junk food culture, how it is, that we are responsible for this. All this happening, and continuously, if you talk about constitutional mandates, particularly Article 21 and 48A, these are the constitutional mandates, and I already mentioned that it's a fundamental duty. It is a fundamental duty of everyone to protect the environment. We have to take our contribute our might to a certain extent, at least little extent, so for the protection of environment. And as you said, these constitutional courts playing a crucial role from time to time for the development of environmental jurisprudence and in achieving the constitutional goals. And hygienic environment is an integral part of right to healthy life, and it is not possible to live with human dignity without human, and the right from the beginning of the Maneka decisions, we are following that, and human right to have human and healthy environment. So therefore, environment protection has now become a matter of grave concern. And it has become, it is how many years, a decade back, we are talking much about environment is very important. Right to live in a wholesome environment is buzzword. But even today, we are speaking about this only. And so MC Mehta and other pioneering heroes of this environmental protection who fought for this. And Supreme Court has recognized the right to clean environment as part of Article 21, as Virendra Gaur and State of Haryana, MC Mehta, so many cases, Kamal Nath case, and MC Mehta versus another, so many cases. A bunch of petitions were filed by MC Mehta, who is considered as champion of environmental concern. And where it is categorically from time to time the Supreme Court observed, we know very well that right to live in a pollution-free environment is a part of fundamental right to life under Article 21 of the Constitution. And not only that, and this right to live in healthy environment uses human rights approach when we talk about to protect environment quality. It is not only the duty of the state and the individual to protect the quality of the environment and upon individual human beings also. And Subhash Kumar versus State of Bihar and so many other cases. The Supreme Court has emphasized the scope of Article Right to Life and 21 include right to a wholesome and clean environment highlighting the correlation between quality of life and environmental conditions. So from time to time and very many occasions, the Supreme Court has emphasized showing concern on environmental issues for the promotion of and protection of environmental conditions. See, so the recent morning, Professor also he has highlighted that the recent judgment, it's a landmark judgment. It's a really significant decision, I can say, by the Supreme Court recently in March 2024. Everyone of all the law students, you have to go through the judgment. It is Ranjit Sinha and others versus Union of India others versus. So where it is emphasized more on, it's a milestone judgment, I can say that. Right to healthy environment, safe from the ill effects of climate change. It was a fundamental human right. That was, it is protected under Article 21 and even as well as 14 also. And he has pointed out, he has shown that high tension wires and all. So the Supreme Court has emphasized in this particular judgment, no, a choice between two good causes. If there is a choice between one good cause and one bad cause, so it is very easy for us to take to leaning towards the good cause. But if two good causes, how it is to be balanced? So wherein the Supreme Court in this Ranjit Sinha case, choice between two good causes, one is promotion of solar power generation and at the same time protection of endangered species. That's what Gibbard he mentioned in the morning. So this judgment really a wonderful decision how it is being addressed on very many based on very many issues. One is that international commitment to environment, for the protection of environment. So India also, like other countries, has joined with other developed nations, has shown concern and committed towards this environmental issues, how to combat the climate change, which is reflected in Kyoto Protocol, Paris Agreement, and basically these two conventions the court has relied on, taken into consideration, and it has emphasized more on how to reduce greenhouse emissions to promote renewable energy. This is one concern the court has relied on in this particular judgment, and right to healthy environment. And directly, earlier and all, we heard much about so many decisions given by the Supreme Court and other high courts, the so-called constitutional courts, and a piecemeal like a right to live in healthy environment, right to have a potable water is integral part of Article 21 like. So in this particular judgment, directly, right to live in healthy environment is a fundamental right. It is an integral part of Article 21 and of course equality also 14 also. And where the right to clean environment that comes within the ambit of 21 is threatened by climate change. So that's the reason why the court has having a serious note on this. And the Supreme Court recognized to healthy environment and right to be free from adverse effect of climate change as an integral part of Article 21. And everyone has right to healthy environment, and it is free from against the adverse effects of climate change. So the importance of solar power as a source of renewable energy, that's also taken into consideration, and promotion of solar energy is a crucial strategy towards to clear the fuels. So therefore, altogether we cannot impose ban on this high power installation of overhead transmission distributors, transmission lines. So that also need to be protected, but how it is to be balanced. Finally, the court has directed to appoint a committee to submit a report. I think it is by end of this month they are supposed to submit a report. With this, the court may take the concerned legislative body has to take appropriate action against this. So therefore, I would like to conclude my paper that so environmental issues, it is a serious matter of concern for both at state level, and even it is a matter of serious concern for the people and individually also, both individually and collectively. So and so that it is to ensure that the development must be without bankrupting the natural resources to the future generations. Future generations also need to be kept in mind, and it is that's the way, that is the sustainable development, and we have to leave the environment even to as for the future generations, and the states have an obligation to play a role as parents' patry to protect the environment and to safeguard and protect the environment, and also for this sustainable development. And so with this, I thank the organizers for giving me the opportunity. Thank you, Ananda, sir.
Thank you, ma'am. I take this moment to invite Professor Dr. Raghunath Reddy, sir, former Professor, Dr. Ambedkar Law University, Tamil Nadu, and Professor Dr. M.K. Ramesh, sir, former Professor, NLSIU, Bengaluru, to take their seats on the dais. Somewhere out there is a tree tirelessly producing oxygen so we can breathe. I think we owe it an apology. I don't want to protect environment. I want to create a world where the environment doesn't need protection. I hereby invite Bhumika Gowda of 10th BLLB to present a brief profile of the speaker, Professor Dr. Raghunath Reddy, sir.
I take immense pleasure to introduce our respected speaker, Professor Dr. Raghunath Reddy, former Professor, Tamil Nadu, Dr. Ambedkar Law University, Chennai. He completed his MS specializing in constitutional and international law. He also secured MBA degree specializing in human resource management from Indira Gandhi National Open University. Sir has experience of 5 years as a lecturer in AC Law College, Guntur, 15 years as assistant and associate professor of law in SK University, Anantapur. And Sir served as professor, former dean and director, Tamil Nadu Ambedkar Law University for 15 years, Chennai. Sir is currently serving as HOD and dean at Bharat Institute of Law, Bharat Institute of Higher Education and Research, Chennai. May I now call upon Professor Dr. Raghunath Reddy, sir. Thank you.
That's it. Thank you, Bhumika. If people destroy something replaceable made by mankind, they are called vandals. If they destroy something irreplaceable made by God, they are called developers. By Joseph Woodcraft. I hereby invite Shivarupini of 2nd Sem 3 years to present a brief profile of the speaker, Professor Dr. M.K. Ramesh, sir.
Ladies and gentlemen, it is my distinct honor to introduce Professor Dr. M.K. Ramesh, a distinguished legal scholar and an esteemed educator whose contribution to the field of environmental law and human rights law are truly exemplary. Our speaker today holds an impressive academic background with a BSc, LLM and PhD from Mysore University. His area of expertise are international law, human rights law, environmental law with a special focus on natural resource management law. He served as a professor and also briefly a vice chancellor at National Law School of India University for almost 3 decades. Our speaker's illustration career includes roles such as distinguished juris professor at HNLU Raipur, advisor to the chancellor at the Vidyashilp University, member of the board of governors at BMS Law College, Bengaluru. He has chaired and also been a vital part of several high-level committees in association with Ministry of Environmental. and the Ministry of Housing and the Urban Poverty Alleviation, and the National Biodiversity Authority. With over 40 years of experience in the legal field, he has made a significant academic contribution, publishing 60 research articles and 5 books. He is also the founder, editor of the Indian Journal of Environmental Law. He has been representative at the International Environmental Law Academy in Ottawa and has been a key member of various ethics and research committees. As a senior Fulbright Fellow and an Environmental Law Fellow at the Environmental Law Institute in Washington, D.C., he has argumented environmental concerns globally and locally. Our speaker today, internationally engagement and extensive, he has been a visiting professor at the renowned institute worldwide, like KTH, Stockholm, Law School of Zurich, Dalhousie Law School, Warwick Law School. Please join me in welcoming a true illuminary in the field of law, whose tireless efforts and collaboration across the global continue to shape our future in legal education and environmental policy across the world. We welcome you, sir.
Thank you, Shivrupani. Sooner or later, we will have to recognize that the earth has rights too, to live without pollution. What mankind must know is that human beings cannot live without Mother Earth, but the planet can live without humans. May I now request Professor Dr. Raghunath Reddy sir, former Professor, Dr. Ambedkar Law University, Tamil Nadu, to speak on the topic Environmental Impact on Renewable Energy Resources.
Professor Dr. C.S. Patil, the chairman of the session, Professor Dr. Ramesh, Professor Revati, the principal, Professor Dr. Kempagowda sir, and others. So it gives me immense pleasure to be a part of this one-day seminar. And the topic is very huge, vast. The morning, the inaugural address, and also the critical, this keynote address, after seeing so many environmentalists and Professor of Environment, Dr. Ramesh, the founder of National Law School and one journal, one separate cell for environmental studies. So, a human being cannot live without a natural environment. As our people are saying, the mother earth, the mother environment. There is a saying, the woman is nature, man is culture. So always it is the man who pollutes nature. Instead of enjoying the beauty of nature, we pollute, we destroy, we plunder the nature. So therefore, try to enjoy the beauty of nature as a human. Man is the culprit, man means a human being. So let us enjoy the beauty of the environment. Friends, there are so many challenges on human-friendly environment. One such biggest challenge is the threats being posed by non-renewable energies, etc. So therefore, we have moved from non-renewable energy to renewable energy, particularly hydrogen as energy, green energies. We talk about everywhere now about the green energies, the sustainable energy. So energy use is indispensable to human life. Without a clean and green energy, a human being is always at risk. Just like a clean and green environment, which is integral to human well-being, clean energies are also very important for human welfare. Renewable energy technologies helps climate change mitigation energy security, and also have economic benefits. It comes from unlimited, naturally replenished resources such as sun, the tides, and wind. They are all renewable energies. Solar power is one of the cleanest form of energy because it does not emit any greenhouse gases that weaken the ozone layer, contributing to global warming. So therefore, this solar power has no harmful byproducts also. But fossil fuels, nuclear fuels are non-renewable energies because it takes millions of years to create them. So therefore, our future is renewable energy. By 2024, it is sustainable energy. It is sustainable because its consumption by humankind always. The use of non-renewable energies will pollute environment, damage earth. Residual products are generally non-biodegradable. Warming of the climate system and increase in global temperatures are generally in the last 50 years is due to increase in anthropogenic greenhouse gas concentrations. Take for example, all our laws, environment, we talk about from Stockholm up to Rio de Janeiro up to Paris Convention, Kyoto Protocol, like that. All these environmental laws, whether it is international or at the national level, they are all anthropocentric, including the decisions, judicial decisions are anthropocentric. They are not ecocentric. I can say this is my personal view. They are not, all these decisions, laws are anthropocentric, not ecocentric. So therefore, currently the world is nowhere near a realistic path to globally decarbonize all energies by 2050. Empowered by the UN General Secretary, General Assembly, resolution, UN General Assembly resolutions on sustainable energy for all, the UN Secretary General Ban Ki-moon set out the global sustainable energy for all challenges for 2030. It is in this background the hydropower assumes significance. Hydropower is the largest modern renewable energy, particularly green hydrogen. Hydrogen energy, which is renewable, always is conducive for human beings. It emits no carbon dioxide. It is hydro energy used as alternative energy throughout the world. It is cost effective and environmental friendly. Green energy is produced with renewable energy and it is projected to grow rapidly in the coming years. Important synergies exist between hydrogen and renewable energy. So, therefore, what we need is, though we have Atomic Energy Act, Electricity, and thereafter so many amendments to Electricity Act, Atomic Energy Act, energy conservation laws, there are so many laws, but still there is no comprehensive law. That need was also felt by the Supreme Court in the recent passed decision, Ranjit Singh versus Union of India. So my friends, energy law, what we require is a comprehensive energy law. The law of conservation of energy is, don't think that it is neither created nor destroyed. Only the energy is converted in one form to another. So therefore, energy law regulates the energy extraction, production, and distribution. Energy law governs the use of and taxation of energy. So therefore, if we use energy, it is don't think that it is destroyed. It is renewable. Always, it can be replenished. Always, it will not run out. So, ensuring universal access to affordable electricity by 2030 means investing in clean energy projects. sources such as solar, wind and thermal. Sustainable, and it is one of the sustainable developmental goals also, as per 7, to ensure access to affordable, sustainable, reliable and modern energy for everyone. Renewable energy is also called as sustainable energy. Hydrogen energy is cheaper, colorless, tasteless, odorless and non-toxic. India has been focusing on renewable energy development programs. India is exploring the use of green hydrogen in transportation. So some time back we were everywhere, traffic pollution, vehicular pollution like that. In Delhi, in all other places, CNG vehicles are there. Now we talk about the battery vehicles. So green hydrogen has a potential to play a crucial role in integrating renewable energy sources in the energy future. Green hydrogen production offers a sustainable alternative to conventional hydrogen production methods, which often rely upon fossil fuels. So this renewable energy is energy from renewable natural resources. What are the renewable natural resources? Which are always replenished on a time scale. So it comes from a source that won't run out. They are natural. So replenishing usually have a low and zero carbon footprints. And the Supreme Court in the Ranjit Sinha versus Union of India has adopted a balanced approach between the conservation and the conservation and protection of the endangered species on the one hand, and also the climate change on the other hand. So this is a progressive judgment in a sense, which was delivered by the Supreme Court. The choice is between promotion of solar power generation on the one hand and protection of endangered species like the morning we had a slide, The Supreme Court reiterated the promotion of solar energy as crucial step in the global transition towards clear fuels. So therefore, friends, as far as the protection of environment is concerned, I don't say that the entire burden, responsibility lies on the government, nor on the parliament, nor on the judiciary. We have umpteen number of judicial decisions. We have, starting from MC Mehta, public-spirited people, social action litigations, public interest litigations. The Supreme Court is inundated with so many litigations. Of course, I agree. It is for the protection of environmental, for the promotion of environmental justice. But the remedies lies not on the Supreme Court alone. The remedy lies not on the law alone. Law alone cannot do anything as far as the environmental protection is concerned. We have so much of responsibility. We have great responsibility as the citizens of this country. It is our responsibility to protect our own environment. Otherwise, we cannot live. Temperatures have risen already. There are everywhere heat waves in North India, water problems. Temperatures have risen, sea level, water level has risen, global warming. So we can't live. So already, I don't say that some of the endangered species are on the brink of extinction. Even the humankind, even the human being is on the brink of extinction if you are going on using, polluting, plundering the natural environment. So therefore, there should be a movement, just like the movement led by public-spirited people, by others, social action litigations. There should be a movement by the people to protect our own environment, to protect our own mother, the Mother Earth. So we know Panchabhutas, how important the Panchabhutas are: air, water, heat. So therefore, without Panchabhutas, we cannot live. There will not be a future for the humankind. So with this, I stop and I thank the organizers for giving me an opportunity to speak to this.
Thank you, sir. Environmental justice is the movement to ensure that no community suffers disproportionate environmental burdens or goes without enjoying fair environmental benefits by Van Jones. May I now request Professor Dr. M.K. Ramesh, sir, former professor, NLSIU Bengaluru, to speak on the topic environmental justice and human rights.
Good afternoon to all of you. The chairman of the session, Mr. C.S. Patil, my old colleague and an associate for a pretty long time, Mr. Raghunath Reddy, the members of the Kilpar Vivekananda Law College, students, the members of the faculty here, many of you are my friends for more than 3-4 decades. Professor Kempegowda, my friend for, I think, almost 4 decades. It delights me to be here. And meeting students has always been a pleasure for a teacher. I cannot say the same about the students. I don't know whether they feel it the same way. And especially when the lunch is very close by, to listen to a lecture would be a very, very tough task. So I dispense with the lecture, which is for about an hour or so. You will have the PPT and you can go through it later. I will just be in conversation with you on the theme that was assigned to me now: environmental justice and human rights. What's the connection between the two? We know about human rights, but what is this environmental justice? Well, if we closely examine, at the root of both environmental justice and human rights, there is equity. Equity brings both of them together. Non-discrimination, ensuring dignity, not in any way exercising any kind of a bias when it comes to the haves and have-nots. Well, these are the things around which the entire human rights jurisprudence is built. And there you talk of individual rights, collective rights, and intergenerational rights, and so on and so forth. You look to the environment, you have the same trajectory of development. There is absolutely no difference at all. The only point of not departure, the only point of wider import that is there for the environment is that it has the capability of subsuming human rights within it. So, you can as well very safely assert human rights is one of the manifestations of and a tool for realization of environmental justice. Not my words. This has come from the highest court of India, the Supreme Court of India. And you know what the highest court of law in India states, as students of law you know, It's the law of the land. And even to this day, it has not been changed. You turn to any provision in the Constitution, you don't see anything like environmental justice or environmental right or anything like that. But the imaginative interpretation of the highest court of law in India has made it possible that it can get integrated with any of the fundamental rights that you cherish, any of the fundamental rights that are constitutionally guaranteed rights. This is an imaginative interpretation hailed the world over as a trailblazer for the evolution of jurisprudence on the subject. So, Indian highest court has not just rendered service to we Indians, but to the entire globe. And some of the ideas of this are to be found in the legal systems elsewhere. And I will refer to something that happened just last week in the entire European Union. A real. And as students of law here, you must really take interest in this particular theme. That what we look at something as a strange thing as environmental justice is not something which is outside us. It's the other way around. We are within it. And that which circumscribes, overwhelms us, the environment that we know of, also is in need of justice. And it's only through law, through interpretation of law, through enterprising advocates like you, this environmental justice could be realized. But let's just try to conceptualize what is environmental justice. I have been speaking in abstract terms so far. At least we are very clear about human rights, but what is this environmental justice? To start with, the environmental justice was more of a human rights movement, a social movement. Although it was a misnomer to call it as environmental justice, but it was called as environmental justice movement. It started sometime around 1980s in one of the counties in California. It was an instance where it's called as the Love Canal case. Easy to remember, no? For young people, Love Canal case. No, they're savoring. They don't express it before very distinguished people like you, but they will enjoy it later. And I will have a conversation with them on that later if time permits. Well, it has nothing to do with love, nor with canal, but it's an area. All that happened was the municipal council had a very lofty objective of finding a reasonable living space for the colored people, the black. In the United States, you call them as colored people. Most of them are laborers, agricultural laborers or industrial laborers. So they are one of those unfortunate ones in the society who are not in a position to live just like their brethren. And here the municipality came up with a grandiloquent plan that we will find housing for them. To cut a long story short, they were able to build houses for them, locate them. Quite a good number of colored people were housed there. But the real problem started a couple of years later, when each one of them, each of the households started developing health problems. And later it was discovered, I'm accelerating the entire idea, it came to light that this housing colony was built on a waste site on a filled waste site. All chemicals of the city were dumped there, a wasteland, and later a colony, a layout. Just like any of the layouts that you have. But you know, the environment in which you live is also get affected by the contamination that the soil endures, and the effect will be on you. The air you breathe, the water you consume, and they develop health problems. There began this environmental justice movement. It was one of the triggers. There were many other. I'm just giving you one example. That it is an approach which is subaltern. The have-nots in the society, the poorer sections of society, they have the same kind of a right to breathe clean air, to drink potable water as the haves in the society have. This is the movement. And they called it as an environmental justice movement. A very narrow human rights approach. But you know very well that when it touches on human rights, it catches one's attention. And when once you know that there is discrimination in such an evolved society like United States, then the powers that be will be a little alert. And so corrective measures are going to be taken. But if you only talk about environment, conservation and protection, nobody would care. But if it touches upon your life, on your health, hygiene and things like that, we are very familiar with the COVID-19, and so I need not have to recall that to you as to how people reacted, at least for 2 years, and how people became more hygienically well-groomed than they were earlier, and have forgotten it now. That's a different thing. But the point is that, and that's what environment keeps on telling us, that if you keep yourself clean and keep your environment clean, you have a good quality of life. And right to life, a fundamental right, invariably require that quality of life for you, which is possible only when you have a clean environment. Well, the connection was drawn, and it became a huge movement over a period of time, bringing in so many changes in the way in which the municipal administration would function, the way in which the state agencies would act, the way in which the mindset of the people with regard to the poor or the rich, as far as the claims over nature, equal, equitable, without discrimination. That's the kind of development that you see in those 3-4 decades of the evolution of this environmental justice movement. It was a very narrow focus, but the same focus was put to greatest use by our codes of law. And I recall, just for your information, because I know that many of the environmental rights cases were discussed in the earlier session, and also as I was just walking in, I could hear a few of the cases about right to environment. I will not repeat any of them. I just refer to only one case. Way back in 1992, the Supreme Court came up with a landmark judgment, which even to this day is the law of the land, unchanged. I think in the last session you had something on EIA law, but much before that. And long time before what we could ever think about environmental justice, you do get it through the highest court of law in India. This is popularly known as the Sariska case, Tarun Bharat Sangh Alwar versus the state of Rajasthan, the 1992 Supreme Court judgment. I will not go into all the details of it. I will just only pick the principle and then place it before you. The principle is simply this, The court very cleverly made use of the Kautilya's Arthashastra and paraphrased it and applied it to environment. What did the court say? If your individual interest or right is affected, the state should take action. It has to be protected. But supposing your individual right comes in conflict with that of the family, the familial right will be superior to you. And if the familial right comes in conflict with that of the communitarian right, community right trumps the family right. And so on. The court goes on like that by using Kautilya's Arthashastra's strategy and says that if the state interest gets affected by promoting communitarian interest, the state interest prevails over that. That's where Kautilya stopped. But the Supreme Court went a step ahead. If the environmental integrity is at stake, it is superior to the state interest. Please note this. Every policymaker in India, every lawmaker in India need have to note this. Unless the parliament thinks of changing the law on that, this still stands as the law of the land. The highest priority is being given to environmental integrity. And so now I draw the widest concept of environmental justice, that environmental justice is not just confined to human rights or promotion of human rights, which the court found it convenient and strategically useful to make use of as a tool. But much more than that, it is more to do with conservation, non-degradation, protection, not antithetical to development. That's what the previous speaker was saying, that without bankrupting the environment you can develop. That's what she said, if I use your words. And that's what precisely in 1992 a policy document prepared by Government of India said. The basic principles of conservation, environmental protection and development. This was done just on the heels of the second global summit on the environment. It was called as the Summit on Environment and Development, 1992, Rio de Janeiro. It's a very path-breaking idea that was expressed, that development and environment are not antithetical to each other. If only you conserve and if you have resource, and if you have the resource available, you can put it to developmental requirements. But if you don't have the resource, where is the scope for development? And so, it's imperative, non-negotiable, that certain resources, the quintessential quality and their integrity need have to be protected, conserved, come what may. And what you use, to make use of the expression of one of those scholars who use this expression, that you can use only that ecological surplus, that which the nature gives you as a bounty, that you can use for all your developmental needs. And there's plenty on earth. There is plenty on earth to meet every conceivable developmental demand of us, without affecting the intrinsic value, worth and integrity of that environmental resource. What is this ecological surplus? It is just like the money deposited in the bank, you get interest out of it, that interest you use. You don't touch the corpus, because once you start exhausting the corpus, there will be nothing to fall back upon. The Mother Earth, the environment is something to fall back upon. And that's always there to support us. But if you just remove that support, where do you go? Gravitational pull, no, it takes you to the nebula. There is no human existence. There is no life on earth. Very easy to say, but very difficult to practice, because all along, the people have been talking about environment. I think every 5th of June for photo ops and to get photos in the newspapers and the media, people go on talking about environmental concern, that they're environmentalists and things like that. But my simple request to each one is essentially to think inwards and then see how environment unfriendly we have been and how we really reduce that kind of an impact on the environment, which is possible. Not just with modern technology, we can, by making use of the modern technology, we can, as in the climate negotiations, it has been established that we can switch over to different kind of technology, cleaner technology. It takes time, but you need to get into that. No choice, because there is no future for humanity. So we are talking of intergenerational equity, a human right. The resources that are available is not something that we alone have an exclusive right over, but it is something that is shared with the generations to come. Look at that. There is equity here, intergenerational equity. Generations, across generations, there is equity here. Resources were there for the previous generation, and it has been there with us now, and we needed to pass on this environment, performing the kind of functions it is performing, the ecological services it's rendering, to be available for the generation subsequent. That's the idea. And they're talking of human rights here, and that is environmental justice for you. But then how environmental justice could be realized? Well, there is a roadmap that has been laid down in my PPT. It has already been put together. I will just give you a small capsule of it. That first the thing that you need to know, internationally recognized, is that you need to respect the rule of environmental law. Rule of law, we know. Rule of environmental law. Why do you make environmental regulations? You obviously make environmental regulations not to oppose any development, but to make development sustainable, but to make development environment friendly. And further, these regulations, the pollution control, all these, respect them. Respect, comply, conform. I have a little bit of a difficulty with this cooler. Can it be lowered a bit? ಸ್ವಲ್ಪ ಕಡಿಮೆ ಮಾಡ್ತೀರಾ? Okay, no problem. I cannot escape it then. Only thing is, I will be a nuisance for you when I cough. Somehow I am allergic to coolers and air conditioners. Anyway, let's live with it. The idea of accessing, securing, and realizing environmental justice, the first step is to ensure that you respect the rule of environmental law. The second one is to access environmental justice. You need institutional arrangements. You have the Legal Services Authority. You have the Lokayukta. You have these institutions and institutional arrangements at one level. And you have within the statutory frame the administrative agencies which also have an appellate function to perform. These institutions should be accessible for you to seek justice. Not just for yourself, but for the environment as well. It was almost unheard of till around 1970s and 80s when a great scholar, Oliver Stone, wrote a small article entitled, it's there in the American Journal of International Law, Do Trees Have Standing? As lawyers, you know what standing means. Standing is entitlement, a right to bring a legal action. Standing to sue. Isn't it? When do you get that? When you have a right. When you have a right which has been violated. And here is a kind of a metaphorical statement made by the author here. Do trees have standing? What do you mean? Trees stand. Once you cut it, it becomes a log of wood. So trees always stand. But he wants to mean that do trees have legal standing to seek and secure justice? People poo-pooed that idea when he came up with this particular idea. But then it was found that in the legal jurisprudence that we know of, one need not have a voice, one need not have the physical ability to go and approach the court of law and knock at the doors of justice, but there can be a next friend in the case of a minor, in the case of an invalid, in the case of someone who is a lunatic. There can be a next friend who can espouse his cause and bring in an action and secure the right for that person. Same thing is with regard to environment. But who are the ones who can hold the hand of environment, seek and secure justice? It's there in our constitution. You have the state and state agencies not as a just next friend, but as a public trustee. Please refer to Article 49A, capital A. Please refer to Article 39, Clause B and Clause C. The state is ordained that there shall not be any discrimination in the accessing, securing benefits of any resource, and the economic system shall not be worked to the detriment of any section of society. And resources, material resources, that's the expression used in the Constitution, that material resource actually includes the environmental resources. And you have the other directive principle, which actually says that the state has the primary duty to take care of, to maintain, to manage, and to improve the quality of environment. It's only a public trustee who can do that. The state and state agencies are public trustees. A trustee is reposed in them, and they shall not betray. In the Supreme Court, for well over 2 decades, this has been beautifully expressed. There is that Tamil Nadu case and the following cases after that, the public trust doctrine. And you also have the parent's patria position. In the position of a parent, in the position of the head, mukhya, you will take care of all those who are under your dependence. And that's the duty which the state and state agencies own. They don't own anything, because we, the people of India, own everything. Because environment and environmental resources are commons, common property resource. But there is a mechanism whereby these could be realized and these could be enjoyed, the benefits could be secured. We are beneficiaries, but there's one more thing. We have a fundamental duty. And what is that fundamental duty? The same duty that is cast on the state and state agencies. Article 51, capital A, small g. Please read that. I and you have the same duty, same responsibility of taking care, protecting, maintaining, managing, improving the quality, acting as eyes and ears of the administration to help them with any kind of a deviation, reporting about that, complaining about that, assisting them in their work and things like that, so as to conserve, protect and improve the quality of environment. So, the next friend is there in you, in the state and state agencies, to take care of the environment for a very selfish reason, for our own good. It's not just that the environment should be protected for environment's sake. It's for ours. Very anthropocentric. So, if you want to survive, if you want to lead a good quality of life, and if you want to ensure that your quality of life would continue uninterrupted for all times to come, you have no choice. You have no choice. And that is something which there is no compromise, that you have to take care of what? Environment. So environmental justice owes this. These are the limbs of the concept of environmental justice. Very much rooted, not just in human rights, it is rooted in humans. It is rooted in ethical code of conduct. There is some ethics in the way in which we live. How we live and what quality of life we have. Very closely related to the environment. And that's exactly the reason why every human being should think that he is not apart from nature, but he is part of nature. Just last week, there has been a real paradigmatic shift in the way of thinking of the European Union. European Union. Last Monday, just 1 week back, the European Union came up with a new law, Nature Restoration Law. Do a bit of homework. Please read what is that about. Wonderful work. But there are very many inspirations for that. Nature Restoration Law. And even within the European Union, there is a churning. Of the 27 countries, very powerful nations were opposed to it. If you want to restore nature, what will happen to development? That's a kind of argument, always, the mainstream argument. And in the European Union, to make something as law, you need two things. One is 55% of the members should support the motion. And second, 2/3 of the European population are being represented in the voting. That means those many countries. So out of the 27, there was more than a dozen countries which were opposed to it. It was tabled in the year 2022. It passed muster now. 20 countries supported, all major countries. Netherlands is the only one which is opposing it. Belgium and Austria and a few others, they abstained from voting. They have made a new law. Now you are no longer thinking in terms of just pay some money and be done with it for any damage that you have caused to the environment. There has to be a proper assessment of it, and the compensation that you pay should be in proportion to the damage caused. Well, certain calculations are there, certain markers are involved in it, there are certain difficulties in it also. But don't think that this is a new thing. It happened in India. The Uttarakhand High Court, a few years back, in the Ganga and Yamuna pollution cases, came up with this idea that these rivers also are a legal entity. They have the right of their own, and they need to be conserved, protected, maintained, managed, and improved. A basic obligation on the state and also those who are attempting to pollute it to refrain from any such activity. And should they do that, penal consequences should follow. That's the sum and substance of the High Court judgment there. So the jurisprudence in this is evolving now. Very long journey. It's not that easy to realize environmental justice. In fact, there is a very thought-provoking note to this European Union law prepared by Professor Sairam Bhatt, my colleague. I think people should read that. You will find there are so many problems as to how you are going to realize it, but it's possible. It's possible for you, me, and now here itself. And once again, the formula comes from India again. There was this conference of parties, the 25th, 26th, and 27th, these three conference of parties. Only one stream of thought underlined this conference of parties on climate change. And that idea came from India. Mission Life. Capital L, small I, capital F, capital E. Mission Life. Lifestyle for environment. What does that convey? It simply conveys something about consumer choice. I and you are consumers of goods and services. When we make our choice, we make such a choice to ensure that the choices we make are environmentally benign, environment friendly. There's a magic here. Charity begins at home. You start from you. Consumer is a very powerful thing. I and you may not realize it now, but when once it becomes a kind of a movement of making such a kind of a choice, how British were thrown out of India, it is only through such a movement, Swadeshi movement. Quit India had its roots in Swadeshi. Same thing here can also happen. And that's what the Prime Minister of India gave to the world. This is amazing, I tell you. I tell you why. Because in international relations, as it is the case of domestic law, the greatest polluter, the greatest contaminant, and the one which is actually causing all harm to the environment is going scot-free. No law, no administration, no policy maker, no political leadership has been able to control, contain, regulate, limit their impacts, whatever the kind of laws that you have. This has been my experience in these 30 odd years of teaching environmental law. People may talk so many things, but when it comes to political will and administrative will, it is found wanting. And that's the case at the international level as well. Climate change arrangement has been a failure precisely for this, that the corporate entities were not brought to heels. They were not made accountable. We know the facts. Facts are staring before us, but still nothing is happening on that, precisely for the reason that governments and states do not really be able to take action firmly on those which, under the garb of development, cause destructive development. So what is the weapon now? The people's movement. And if people make up their mind that these are the choices that I make, you can start with the vegetables that you purchase in the market. Why go for the Australian apples? You have something that's available, grown at your background. More tastier, more organic, less chemical. Make choices like that. It can transform society. It can transform the way we think. It can transform the way in which the supplier, the trader, the dealer, the retailer, the wholesaler will have to come in line, because consumer demand has to be met by them. And without the consumer, people will be out of business. Well, solutions are simple but difficult to adapt. That depends on whether you prioritize environmental justice, and if that is so, we have no choice except this. Thank you.
Thank you, sir. We spend billions of dollars to find life on other planets and trillions of dollars killing the life on this one. If you really think the environment is less important than the economy, try holding your breath while you count the money. May I now request the respected chairperson of this session, Professor Dr. C.S. Patil, Sir, Director Research, Kilpa, to share some of your thoughts with us.
Before sharing of facts, when specialists speak, generalists should listen. I am really benefited by the three discourses that were presented here. I only congratulate Sir Dr. Reddy Revati and Professor M.K. Ramesh, who is a doyen in the field of environmental law, and we are the beneficiaries of several workshops, conferences, training programs that we have done in the National Law School of India University. So, in a very simple manner, he has given us wonderful inputs and formulae. And Dr. Raghunath Reddy, sir, it is a privilege to be on the stage with these three luminaries, experts in the field of law. I thank the Vivekananda Law College for bestowing this excellent opportunity upon me. Thank you very much.
Thank you, sir. Imagine if trees gave off Wi-Fi signals. We should be planting so many trees and we would probably save the planet too. Too bad they produce the oxygen we breathe. I hereby invite Salagaud of 6th BALLB to propose the vote of thanks.
Afternoon, distinguished speakers and dear participants. I take great honor and privilege to extend the vote of thanks on behalf of Janata Education Society's Vivekananda College of Law. We have had the opportunity to delve into some truly compelling and thought-provoking topics concerning our environment and the crucial role we play in its protection and preservation. Firstly, I extend my deepest gratitude to our chairperson, Dr. C. Your guidance and expertise have greatly enriched today's session. Thank you very much, sir. I sincerely thank Professor Dr. M.K. Ramesh sir for his thought-provoking lecture. Thank you very much, sir. May I now request felicitation to Professor Ramesh sir. Thank you, sir. I would also like to express my heartfelt gratitude to Professor Dr. Raghunath Reddy sir for his enlightening discourse. Thank you very much, sir. May I now request felicitation to Raghunath Reddy sir. Thank you, sir. I sincerely thank Professor. Reddy Vari Revati ma'am.
Lunch will be being served in the parking, and after lunch the offline presentations will be in the auditorium only. So those who are presenting papers offline